I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association. And today I'm delighted to introduce our speaker, Scott Hervey. Scott is a corporate entertainment and intellectual property attorney at Weintraub Tobin, and he brings decades of experience advising clients at the intersection of business, media, and intellectual property law. His practice spans the entertainment, digital media, creator economy, and consumer product sectors, where he helps clients navigate the complexities of building and scaling their businesses in an evolving marketplace. As the founder and host of the Briefing podcast, Scott shares his insights on cutting edge issues in IP and media law, helping creators and industry professionals understand and capitalize on the legal and business dynamics shaping today's creator economy. His blend of legal expertise, business insight, and strategic vision has made him a trusted counselor to clients growing their presence and profitability in the digital media and entertainment landscape. We can't wait to hear what he has to share with us today, so I'm going to turn it over to him now.
Thank you, Alla, for that warm introduction and welcome everybody. So we're going to talk about a couple of recent cases at the Ninth Circuit. On first blush, you might look at these cases and think they really aren't, other than just being copyright cases, they're not very similar, but there's some very interesting similarities. Um, so let's go over the agenda, shall we? Put questions in the Q&A, and at the end of the program, if we have some time left, I will get to it. Okay, so today we're talking about kind of these two cases, Seldick versus von Reschenberg, better known as the Miles Davis tattoo case, and then Yone versus Paramount Pictures, better known as the Maverick Top Gun case. We're going to talk about some of the long-term implications from the Sedlick case. And we're going to, I don't know, look at our crystal ball or our magic eight ball and think about the future of substantial similarity analysis post intrinsic test, really post the Sedlick case. But with that, why don't we dive into, let's dive in the Sedlick. So Sedlick versus von Draschenberg is a case that began with a tattoo of jazz legend, and it ended with two Ninth Circuit judges calling for the death of one of the circuit's most established copyright doctrines. We'll explore why a tattoo that looks nearly identical to a photograph can be found not substantially similar as a matter of law, and what this means for the future of the Ninth Circuit's bifurcated infringement test. So the plaintiff, Jeffrey Sedlick, is a renowned photographer. As a matter of just as an aside, we did a podcast episode on this case, and he called me, and we had an opportunity to talk. It was pretty neat. Anyways, he's a renowned photographer who, in 1989, created an iconic portrait of Miles Davis. This photo features Miles Davis in a gesture against a backlit background. Sedlick testified to the meticulous selection and arrangement involving lighting, the precise positioning of his fingers to represent musical notes, and hairstyling. If you look at the photograph, one would think, okay, that's done in like some dark jazz club. But no, this was actually done in the middle of the day at Miles Davis's beach house outside. Um, so this photo was first published as part of a cover story for the Jazz's magazine in 1989. The portrait became an iconic representation of Davis, and it was featured in Life magazine's Picture of the Year, and it was licensed by Sedlick for use on a wide variety of merch. So the defendant is Catherine von Derschenberg. I'm probably not pronouncing her last name correctly, so apologies. But she's better known as Kat Von D, the celebrity tattoo artist. Uh, from, I think it's inked on Discovery. In 2017, she tattooed a photorealistic version of that image onto a client's arm. While she did not charge for this tattoo, she did feature the process and the final result across her social media platforms uh, for the purpose primarily of promoting her tattoo shop. So there was no real dispute that Kat Von D copied the photograph of Miles Davis in creating her tattoo. As part of the process, she traced it on a light box, transferred it to a stencil to her client's arm, and then tattooed that image with the photograph beside her as a reference, as you can see right here on screen. The result was a process which she claimed on social media produces a result, quote, 100% exactly the same, close quote. So Sedlick, of course, sued for infringement in the Central District of California. The district court denied cross motions for summary judgment. On Sedlick's motion, the court found a tribal issue of fact or tribal issues of fact surrounding whether the works were substantially similar, and the court focused on certain differences between Sedlick's photo and the tattoo, namely the light and the shading on Davis's face, the hairline, and the background. As for Von D's motion for summary judgment on fair use, the court too found questions for the jury. So, as you know, there are four key factors that the court look at when deciding whether or not a use qualifies as fair use. The first is the purpose and character of the use, including whether it's commercial and whether that use is transformative, as established by the Supreme Court in the case of Campbell versus Acuff Rose Music. Transformativeness occurs when a new work adds something new with a further purpose or a different character, altering the first with a new expression or new meaning. The court's hearing of this motion was before Warhol, but the Warhol decision now requires courts to ask, as part of this first factor, whether and to what extent the use at issue has a purpose or character that is different from the original, and whether that supports a justification for copying. So now the first fair use factor will analyze whether the purpose of the use of the second work is different enough from the first to reasonably justify a copying. So the second and third factor, the nature of the copyrighted work and the amount and substantiality of the portion used. In this case, the Sedlick case, the court found that these factors weighed against fair use. Lastly, the effect of the use on the potential market for the original work. Here, the court found no evidence that the tattoo is a substitute for the primary market for Sedlick's photo, but the court did find a tribal issue with regard to whether there is a market for future uses of the image as a tattoo. All right. So after these cross motions for summary judgment were denied, the case went to a jury in January of 2024. The jury's verdict was a surprise to many. The jury found that the tattoo and the five related works were not substantially similar to the photograph. For the four process images, social media posts where the original photograph was actually visible in the background, the jury found that they were similar but excused the use under the fair use doctrine. Okay. So to understand how the jury reached this result, we must look at how the Ninth Circuit's unique two-part test for substantial similarity. It's the extrinsic intrinsic test. So the extrinsic test, this is the part that's reserved for the court. It's an objective analytic dissection of the works, and here the court will filter out unprotectable elements like ideas and facts and scenes of fare, and it will then compare only the protectable expressions of the allegedly infringed work with the allegedly infringing work. This stage allows for expert testimony. Um, if the court does not deal with the case at that time, usually it's on a motion for summary judgment. So thereby finding a tribal issue of material fact as to whether or not there is substantial similarity, and the case goes to the jury, then the jury will employ the intrinsic test. So this test is an entirely subjective test, and it asks whether an ordinary reasonable observer would find the total concept and feel of the two works to be substantially similar. This test for similarity of expression is from the standpoint of an ordinary reasonable observer with no expert assistance. So there's no expert assistance here to tell the jury what elements are protectable under copyright law and what elements are not. This stage is reserved exclusively for the trier of fact, to the jury. Okay, so this brings us to Sedlick's appeal. So on appeal of the jury verdict, Sedlick tried to argue that no reasonable juror could find that the works were not substantially similar to the photograph. That was the only argument that was available to Sedlick on appeal, that the jury's verdict was contrary to the only reasonable conclusion permitted by the evidence for both the intrinsic and the extrinsic test, since both tests are required for substantial similarity. The Ninth Circuit issued a per curiam opinion affirming the judgment, the court's reasoning, highlighting a major hurdle for copyright appellants. So the panel held that because the jury found no similarity under the intrinsic test, they didn't even need to reach the extrinsic test, because the extrinsic test is essentially a gut check by lay people. The court ruled that it could not second guess the jury's subjective interpretation. Effectively, once a jury finds no intrinsic similarity, the verdict becomes virtually unreviewable on appeal. And the court openly acknowledged that the intrinsic test is uniquely suited to the jury and therefore nearly immune from appellate review. So this is why Judge Wardlaw's concurrence is so important. In her concurrence, Judge Wardlaw said that the intrinsic test, divorced from analysis of protectable elements, is legally incoherent. Judge Wardlaw and Judge Johnstone's concurrence, they basically say that the intrinsic test is broken. So Judge Wardlaw's concurrence to call for reform. While the court followed precedent, Judge Wardlaw, joined by Judge Johnstone, wrote really blistering concurrences. Judge Wardlaw argued that the intrinsic test is fundamentally flawed and should be disregarded. The intrinsic test, it's a holistic comparison that focuses on whether the works are substantially similar in total concept and the feel of the works. And then, with no more guidance, the jury is left to consider this holistic comparison of the total concept and feel of the two works. She noted that in this case, this test allowed a jury to ignore a, quote, 100% exactly the same, close quote, reproduction because of a, quote, empty standard, close quote. Her primary legal critique is that the total concept and feel standard actually contradicts Section 102B of the Copyright Act, which expressly states that copyright does not protect concepts. By inviting judges to find infringement, by inviting juries to find infringement based on concept and feel, risks collapsing the idea expression distinction entirely. Judge Johnstone reminds us where this phrase total concept and feel came from. Uh, it came from a 1970 case of Roth greeting cards versus United Card Company. And that phrase was used to refer to the protectable selection and arrangement of otherwise unprotectable elements. Over time, other courts have expanded this phrase that related to the concept of separating the protectable from the unprotectable, to a standalone infringement test that does not have anything to do with separating the protectable from the unprotectable. I mean, it's just ironic. By 1990, the total concept and feel test became the intrinsic test. Basically, the jury's opportunity to say, I know it when I see it. Okay, so um, we have two concurring opinions that call for the of end of this test. So, what might a new test look like? Uh, let's start with the Second Circuit, which has a more discerning ordinary observer test here. And in this test, the examination of the work includes, um, in determining substantial similarity in the Second Circuit, the district will filter out the unprotectable similarities, review whether there are any similarities that remain in light of the overall concept and feel, and dismiss on that basis as a matter of law if the two works are not substantially similar. So here, every aspect of substantial similarity, including the subjective question of whether or not there is a shared concept and feel, that can be determined by a court. Now, the Tenth Circuit has a test. They use the abstraction filtration comparison test. This is a model that's often reserved for software cases, but it's applied broadly in the 10th Circuit. This test involves three steps. First step is the abstraction, which is breaking down the work into ideas and expression. The filtering, which is the removing of unpredictable elements like ideas or public domain material. And then the comparison, assessing if the remaining protectable elements are substantially similar to the defendant's work, requiring then the unprotectable material to be filtered out before judging the overall similarity of the protectable expression. Now, Judge Wardlaw suggests uh, focusing the test on the filtration of protectable and unprotectable elements, and remove any inquiry into a work's total concept and feel. So, despite all these different tests and the different tests suggested by Judge Wardlaw, most of the circuits follow kind of the same general format. They separate the unprotectable from the protectable elements and compare only the protectable elements. The Ninth Circuit seems to be the only outlier here, where the Ninth Circuit has this uh, expert in intensive extrinsic analysis that's left only to the judges, and then this subjective intrinsic analysis that's left entirely to the juries. We're gonna have to see what the courts actually do here, and we'll have to see if the Ninth Circuit essentially takes on this invitation to adopt a new form of analysis of substantial similarity. Uh, Next, we're going to talk about Yone versus Paramount Pictures. Um, I like to say today we're heading into the danger zone, not the cockpit of an F-14, but the equally turbulent waters of the extrinsic test for substantial similarity. So, this case, Paramount versus Yone, it isn't just about $1 billion blockbuster. It's really a deep analysis in how courts filter out facts from fiction and how the Ninth Circuit treats the selection and arrangement of unprotectable elements. So let's break down how Paramount secured a summary judgment victory that effectively cleared Top Gun Maverick for takeoff. So here's the origin story. It begins in 1983 when Ehud Yone published Top Guns in California Magazine. The article was an inside look at the real Navy fighter weapons school, Top Gun, based out of Miramar, California. The article begins with a vivid description of two Top Gun F-14 Tomcat aviators, Yogi and Possum, on a hop, a simulated dogfight training, against Top Gun instructors. And then the article continues with a deep dive into what makes Yogi and Possum and other fighter pilots tick. The article takes a look at the Top Gun training regimen, what life on base is like, and the history of Top Gun itself. When the article was published, it was and optioned by Paramount. And in the credits for Top Gun, Yone is credited as on the original movie as the writer of the magazine article. So there are certainly elements in the article that made it into the original movie, Top Gun. The fact that students practice against instructors, the fact that small replica jets on sticks were at that time actually used in training, the tight relationship between the pilot and his radar intercept officer, the kind of high octane testosterone fueled personalities of these aviators. Uh, they just jump off the page. The article even covers an incident where Yogi and Possum, stationed on a carrier in the Indian Ocean, are dispatched to intercept a Russian plane, not a fighter as depicted in the movie, but a cargo plane, not really as, exciting as fighter jets, but nonetheless, and then escorting that errant plane away. The F-14 is so close that the aviators see the Russian pilots snapping photos of them. There is even a picture of that in the article of two Blue Angels F-14s in back-to-back maneuvers. So, following Ehud Yone's death, his heirs exercised their right to terminate the 1983 grant under Section 203A3, effective in 2020 when Top Gun Maverick was released in 2022. The Yones sued, alleging that the sequel, produced without a new license, allegedly infringed the copyright in the original article. So, just a little quick word about Section 203. So, text Section 203 of the Copyright Act permits authors, or if the author is not alive, their surviving spouses or children or grandchildren and others, to terminate grants of copyright assignments and licenses that were made on or after January 1, 1978, when certain conditions have been met. Upon the effective date of termination, all rights in the works that were covered by the terminated grant revert to the author. However, any derivative works prepared under the authority of the grant before its termination may continue to be utilized under the terms of the grant after its termination. But this privilege does not extend to the preparation after the termination of any other derivative works based on the copyrighted work covered by the terminated grant. Okay, so the Yones, if you followed this case, you know that the Yones took the first sortie in the copyright fight with Paramount. At the district court, Paramount filed a motion to dismiss, arguing that the works were not substantially similar because the Yone article is a work of unprotectable fact. In order to state a claim for infringement, a plaintiff must show substantial similarity between the work's protected elements. Determining whether works are substantially similar, as we know, involves a two-part analysis consisting of the extrinsic and the intrinsic test. The extrinsic test assesses the objective similarities of the two works, focusing only on protectable elements of the plaintiff's expression. In its motion to dismiss, Paramount argued that in applying the extrinsic test and by filtering out the elements that are not protectable under copyright law, so that's facts, ideas, sans affaire, which include situations and incidents that flow naturally from a basic plot premise, and stock elements, the two works, Maverick and the article, are not substantially similar. In its motion to dismiss, Paramount argued that all elements that are alleged to be similar, the history and operations of the Top Gun Academy, the fact that pilots pull off risky aerial maneuvers, that the manner of combat training and tactical discussions and that the pilots have, the description and depiction of the fighter jets, including their exorbitant cost, pilots doing push-ups, pilots' use of call signs, nicknames, and the description of camaraderie among the pilots, including bar excursions and games, are reported in the article as factual. So Yone's counsel were ready for Paramount and had their own evasive maneuvers ready to go. In reading the district court's denial of Paramount's motion to dismiss, the key argument which resonated with the court was essentially that it would be contrary to Ninth Circuit precedent to dismiss Yone's case at such an early stage. Because the analytical dissection required to separate protectable from non-protectable elements, which also generally involves expert testimony, and therefore the determination of substantial similarity between protected elements of works which are usually extremely close issues of fact, the Ninth Circuit generally disfavors dismissals on grounds of substantial similarity at the Rule 12b6 stage. That was their hook, and the court bought it. So, in opposition to Paramount's motion to dismiss, the Yones argued that, but for Ehud Yone's literary efforts and his stories, evocative prose, and narrative, the Top Gun sequel would not exist. The Yones argued that if Paramount was only interested in the facts about Miramar Naval Air Station, it would have drawn inspiration from the Senate report Paramount equated Yone's article to. The Yones argued that it was the expressive imagery, engaging action, engaging character traits, and themes contained within the original article that were the reasons why Paramount optioned the article in the first place. The Yones point to a list of more than 70 alleged substantially similar, more than 70 alleged substantial similarities between the original article and the sequel, and that was enough for the district court. The court found that there were enough similarities between the article and Top Gun Maverick for reasonable minds to differ on the issue of substantial similarity, including the filtering out of unprotectable elements and additional development of the factual record would shed light on the issues pertinent to the court's analysis under the extrinsic test. Well, even though Yone took the first sortie, Paramount was eventually able to splash the Yones lawsuit at the district court. In Paramount's motion for summary judgment, the court said that any similarities between the article and the sequel were essentially due to the inclusion of unprotectable facts, general plot ideas, or sans affaire. The fact that both the article and the sequel contain Top Gun instructors and graduate fighter pilots is not actionable since these are factual elements and not protected by copyright. The fact that the article and the sequel are similar because they depict or describe fighter pilots landing on an aircraft character, being shot down while flying, and carousing at a bar is a showing of familiar stock scenes or sans affaire. The court also found significant portions of the article and the movie dissimilar. The themes and moods of the two works are dissimilar, as is the dialogue and the selection and arrangement of elements, including the arrangement of the unprotectable elements. Uh, Additionally, the court noted that the dialogue in the article is unprotectable in any event since it is all historical fact. In summing up the court's objective comparison of the work's respective plots, sequences of events, pacing, themes, mood, dialogue, and characters, the court found that they are not substantially similar. And while the article and the sequel have some similarities, those similarities are based on unprotected elements. For example, a general mood that flows naturally from unprotectable basic plot premise is not entitled to protection. And the Ninth Circuit has said in Corbello versus Valley, which is known as the Jersey Boys case, that a character based on a historical figure is not protected for copyright purposes. So the court did take into account the expert testimony of both parties, but it found that the plaintiff's expert testimony was unhelpful and inadmissible because that expert failed to filter out the elements of the article and the sequel that were not protected by copyright law. All right, so the Yones appealed the loss to the Ninth Circuit. The Ninth Circuit, okay, the Ninth Circuit framed the case succinctly, explaining that while the article and the film do share some similarities because they both depict real Navy fighter pilot training programs, that alone is not enough. As the court put it, copyright plaintiffs must show more than an allegedly infringing work's general similarity to their own. They must show what is similar to their original expression. The crux of the Ninth Circuit's affirmation of Paramount's win at the district court lies in the extrinsic test. So, as I've said now, this will be the third time. This is the objective, analytical side of the inquiry where courts filter out unprotectable elements and then compare only the protectable expression that remains. And as you may know, for nonfiction works, copyright protection is deemed to be thin. So this court performed really a methodical filtering of the elements that the Yones claimed supported a finding of substantial similarity. So the first is plot and sequencing. So the article is a nonlinear account of a flight school. The movie is a traditional three-act functional narrative. The court emphasized that Maverick includes major plot elements that simply don't exist in the article, things like the uranium enrichment mission, the Maverick Rooster conflict, a romantic subplot, and the extended combat finale. So, even though both works involve elite fighter pilots and training, the court said those similarities are factual and inevitable when you are depicting a real military program, not protected expression. Characters and settings. The characters in the article were real people, and real people are not protectable under copyright law. The court found that general traits like being competitive or a man's man are too abstract for protection. And frankly, those traits are exactly what you'd expect in any depiction of a fighter pilot. You can't copyright that. Similarly, the plaintiffs pointed out that both works take place in San Diego at the Naval Air Station in Miramar. Just like real people, uh, on which characters are based or maybe based. These are real locations tied to a real program. The court treated that as a factual reality that's not protectable. It's not creative expression. Dialogue. The court actually questioned whether any of the article's dialogue was protectable at all, since it was presented as factual reporting of what real pilots said. And factual reporting, the facts are not protectable by copyright. Even assuming some dialogue could be protected, the court found that none of it appears in Maverick, except for the phrase fight on, which is real world aviation jargon. So there was no meaningful overlap in dialogue, protected or otherwise. The court dealt next with themes, mood, and pace. So the plaintiffs identified themes like redemption, sacrifice, brotherhood, and the dangers of aviation that were all expressed in both the article and in Maverick. However, the court rejected all of these as classic examples of unprotectable ideas. Themes at that level of generality, they simply aren't copyrightable. The court essentially said that allowing protection here would give one author ownership over concepts that belong in the public domain. The plaintiffs made similar arguments about mood shared between both the article and Maverick, nostalgia, romanticism, and intensity. But the court explained that mood alone isn't independently protectable, and any shared mood between the article and the motion picture flow naturally from the subject matter of fighter aviation. So, in other words, if you make a movie about fighter pilots, it's going to feel intense and nostalgic. That doesn't make it infringing. Finally, there was pace. Um, the plaintiffs argued that both works alternate between intense fight sequences and quieter moments on the ground. The court rejected that too, explaining that this pacing reflects how real fighter pilot training actually works, that it's dictated by the subject matter, not by original creative choices. I mean, also, could you imagine a scenario where the pace of a movie like Top Gun Maverick was a protectable element, so you had to choose between either being all intense or all quiet and nostalgic? Lastly, the court dealt with scenes of fare, elements like jocks carousing at a bar, or the presence of a brass bell. Those were all deemed to be stock scenes that naturally flow from the settings of naval aviation. And frankly, those traits are what you'd expect in any depiction of fighter pilots, and you can't copyright that. So once these unprotectable elements are removed, the court found that there was very little left to compare. The court said as follows: we observe a problem that pervades the Yone's arguments. Although the article contains much original protected expression, most notably its vivid phrasing and innovative structure, none of that expression appears in Maverick. Yone's the Yone plaintiffs identify similarities between the article and the film only by describing both works at such a high level of abstraction that the similarities do not involve protected expression. Their claim of substantial similarity fails because what is protected is not similar, and what is similar is not protected. So after filtering out the unprotectable elements, what's left, the actual expressive choices Yone made in writing his article, simply are not reflected in Top Gun Maverick. The panel was very clear that this case fails the extrinsic test. The court said, because Maverick does not share substantial amount of the original expression of Top Gun's The Article, we affirm the district court's grant of summary judgment for Paramount. Um, One argument the heirs pushed hard was that even if the individual elements weren't protected, the selection and arrangement of those elements were, but the Ninth Circuit wasn't persuaded by that argument either. The court explained that the alleged similarities weren't arranged in a sufficiently original or unique way in the article to warrant protection. And in any event, Maverick doesn't replicate that structure. One of the things the Ninth Circuit did very methodically, as I said, is they walked through each category of allegedly similar protected expression, and they found no substantial similarity. So this case, it really isn't a sweeping new doctrine or a major expansion of fair use or copyright defense. Actually, they never got the fair use. To me, it just is a very methodical application of the extrinsic test, and I think litigators should take note of just how methodical the court was and try to replicate that in any motions to dismiss. Um, the court didn't need to reach fair use and it didn't need to reach termination rights in detail. It resolved the case on the cleanest possible ground, no substantial similarity as a matter of law. Here's two interesting points that don't really go to the court's determination of no substantial similarity. Um, the first, it has to do with the expert testimony. The district court excluded the plaintiff's literary expert, Harry Bean, because he refused to filter out unprotectable facts in his analysis. The Ninth Circuit held that this was not the district court's refusal to take into account the plaintiff's expert was not an abuse of discretion. The other interesting element was the contract claim. The Ones argued that Paramount breached the 1983 agreement by not crediting Ehud Yoneh and Maverick. The district court found two conditions for crediting Yoneh in a movie produced by Paramount. And these are the conditions. One, that the movie was produced under the agreement, so the agreement between Yoneh and Paramount, and two, that the movie was substantially based upon or adapted from the article. Because Maverick was not produced under the agreement, the court concluded that Paramount was not required to credit Yoneh. The court, the Ninth Circuit agreed, holding that the word and means and since the movie didn't infringe, it wasn't produced here under, and so no credit was required. Okay. So obviously these cases are different factually, but there are some similarities, and let's take a brief look at them. So the outcome. So both of these cases resulted in wins for the defendant, with the Ninth Circuit affirming that the allegedly infringing works did not infringe upon the original copyrighted work. Both were uh, both were defendant wins at different parts of the trial, obviously, and both were defendants wins. Both defendants won on different elements of the analysis of the extrinsic intrinsic test. The both cases utilize the two-part extrinsic and intrinsic test, but Sedlick focused heavily on the jury's finding of no intrinsic similarity, while Yoneh focused on the lack of extrinsic similarity. Both decisions emphasize filtering out unprotectable elements before determining similarity. I think the Sedlick case shows a risk that I think, well, pundits say both plaintiffs and defendants, but I think, I think it's more defendants face where a ruling of non-infringement is not reached at the summary judgment phase, and where there are numerous shared unprotectable elements. Um, I, I'm not saying that a jury would have found Maverick to be an infringing work, had the case gone to a jury. I think the result would likely have been the same um, as at the district court. Uh, like given the difference in the total work, the motion picture versus the article. You had difference in storylines and also the medium of expression. I think the jury had Yone versus Paramount gone to a jury, I think the jury would likely have found the total concept and feel of the article and of both works um, not to be substantially similar or not to be similar enough to justify finding of substantial similarity. So Sedlick may be remembered as the case that broke the Ninth Circuit's substantial similarity doctrine. If the intrinsic test is eventually abolished, it will represent a massive shift towards a more objective, legally grounded standard for infringement. But for now, the ordinary observer's gut check remains the ultimate and often unreviewable deciding factor where a jury is left to decide substantial similarity. I think Yone reinforces several core principles of intellectual property law specific to the entertainment industry. Um, Nonfiction receives a narrower scope of protection. So studios can draw inspiration from real world events and journalistic reporting and real people, as long as they do not copy the author's specific expressive choices. And then selection and arrangement is not a catch-all. Uh, the court in Ione rejected the argument that specific sequences of facts were protected, noting that the film Top Gun Maverick did not replicate the article's unique structure. Uh, so a couple of emerging themes, and looks like we're going to have about 10 minutes for questions. So hopefully you've loaded up that Q&A. Some emerging themes. Obviously, the first one's pretty obvious. The intrinsic test is under fire. The total concept and feel standard actually contradicts Section 102B of the Copyright Act, which expressly states that copyright does not protect concepts and fosters a result where unprotectable elements are clearly being considered. Also, it's ironic that this phrase had its origin from the separation of protectable and unprotectable elements, and now it's totally dismissed and divorced from that. Um, it's seemingly certain that a new method for determining substantial similarity is going to emerge. It's curious what the factors will be. Um, Second, the importance of judicial determination while uh, our current test still stands. I think Ione underscores the importance of judicial determination of non-infringement prior to trial, where works where the allegedly infringing work incorporates unprotectable elements, and one might say where it incorporates a substantial amount of unprotectable elements. It seems obvious to say, but focus on extrinsic comparison and protectable elements and seek judicial determination of non-infringement if you're the defendant. Obviously, if you're the plaintiff, the goal is to get past the extrinsic comparison and allow the jury to consider the mix of protectable and unprotectable elements as part of the total concept and feel. Once a jury has adjudicated substantial similarity, it's next to impossible to unwind. All right, let me jump to our questions in the Q&A and see if I can give you some answers. Oh, Jay, you're my best friend. You asked a lot of questions. That's great. Okay. Did the plaintiff in Top Gun make an affirmative claim for breach of contract, such as the Coming to America case that Paramount lost. That case interpreted based upon pretty broadly and looks into account the development nexus of the plaintiffs and the defendants' projects, which would have been even clearer here. If so, what was the result? I guess Jay probably wrote that after or before we talked a little bit about the contract claim. So I'm going to go to your next question. The court's analysis suggests Paramount didn't need rights in the article to do the first film either, correct? So why do you think Paramount optioned the article for the title? Something else? Jay, that's a great question. Um, and you have to ask yourself, like, why do studios option life rights agreements for public figures when the story that they want to tell is in the public domain? I think there's a lot of reasons. One, maybe access to research material that didn't appear in the article. Um, I mean, the article was presented as fact, and the article presented depictions of real life people. As we know, the Copyright Act does not protect real persons, nor does the Copyright Act protect facts. It only protects the creative expression of those facts. Now, maybe Paramount determined that the original Top Gun movie and Top Gun's The Article had enough similarities of protectable elements to warrant an option. Maybe Paramount optioned the article because they didn't want another studio to option the article. Maybe they didn't want to deal with a potential copyright infringement claim, which I think is most of the reason why um, studios option works that may not be protectable or enter into life rights agreements with persons when they don't have to. It's just to avoid the hassle and expense of a later claim. I mean, as we know, lawyers are expensive, and the cost of an option might be less than the cost to defend a claim. Certainly, probably was the case here with Maverick. It might be, they might have done it just for the name as well. Even though it's questionable, one, whether Top Gun itself, that phrase or the words Top Gun is protectable by copyright, and also questionable whether or not the word copyright is protectable as a trademark, since it is the title of a single artistic work, and um, under the Lanham Act, titles of single artistic works are not protectable as trademarks. I don't know that I necessarily agree with that, but that is that is the trademark law. Let's see. Jay's got another question. As a drafting tip, after the Top Gun case, should a provision be drafted if the seller of rights in a nonfiction material wants to be entitled to payment for sequels and other subsequent productions? I mean, generally you have in rights agreements, there generally is negotiated either passive payments or some type of other payment related to a sequel or a prequel or some type of subsequent production. Uh, the it, it then it then will focus on whether or not that work would qualify as a subsequent production. Generally, when you're talking about sequels or prequels, there's a they're defined in the Writers Guild of America. Actually, we did a really interesting podcast on the Pitt lawsuit where we analyzed um, the freeze language as it relates to sequels and prequels, and we have some discussion about that. And it relates to this subject matter as well. So anybody who's interested in that, I would encourage you to look for that podcast episode and take a listen because I think it'll provide some clarity here on some drafting suggestions and whether or not one should align their definition of sequels and prequels to the WGA definition or to derivative works as that term is defined in the Copyright Act. Gene asks, where do I find the podcast? As in, where is it available? I did not see it when I scanned the QR code. Oh, I'll have to tell our marketing department. Um, go to your favorite podcast platform, whether that's Apple Podcast or Spotify, and look for The Briefing by Weintraub Tobin, and you should find it. You should find it there. Okay, Jonathan. Oh, okay. Here's some insight. As it happens, Ehud Yonah and I were both staff writers at California Magazine, previously known as New West, and a sister publication of the New York Magazine. At the time the story was published and optioned, it was standard practice at both magazines to actively look for movie deals, and the two studios were willing to make deals with modest prices for risk avoidance. Thanks, Jonathan. Yeah, that's kind of exactly what I said. Um, I will note now. We do, as a outside lawyer for a number of studios, we do see a lot of deal making between studios and uh, magazines, uh, companies that um, magazines or newspapers or what have you, like Condé Nast, Bloomberg, etc. Okay. I have another question. Even if copyright law doesn't protect life story rights, might another doctrine. But then if but then the option a studio would want to buy would be from the real person, not the journalist. So right, you're talking about um, the whole issue of right of publicity and the protectability of an individual's persona. We actually have a couple of podcasts on that subject as well because that comes up quite a bit. Um, the whole issue of um, whether or not an individual's persona is infringed by the depiction of a particular character in a movie or a motion picture. A lot of times it can come up in the context of a defamation lawsuit. Um, Trying to think of some of the podcasts that we have that talk about that. Um, I think if you just, I know that we have at least 4 or 5 episodes where we've addressed that episode, where you addressed that topic. I just can't it's just not coming to the top of mind, any of the episodes right now. But I would just suggest looking through our titles, it would be pretty obvious. Um, Gene, this does make me think of the Haviland versus FX. Uh, yeah, I love that case. That case gives producers quite a bit of latitude in the depiction of real life people and the need not to obtain life story rights. Um, I'm going to close with Jay's last question. Do you think the intrinsic test will ever be fully disregarded? What would it take for that to happen? I'm going to answer that question with a please subscribe to my podcast and we'll let you know exactly what happens. I see that our time is up. I hope you've enjoyed this podcast. I've certainly enjoyed giving it. Thank you to the Beverly Hills Bar Association for allowing me to do this today. And I hope to see you all as subscribers to the briefing.